Hello, welcome everyone to a Keystone Contractors webinar. There's been a large case that we've been tracking and following. It's the Clearfield County Jail case. And our presenter, our speaker today is Mike Pascoe from Ice Miller. Mike penned a amicus brief on behalf of the KCA. And the Supreme Court recently ruled on this decision, so we thought it would be good to have a little discussion about it and kind of get Mike's thoughts on everything. Before we kick it off, you want to take a few minutes to introduce yourself and your firm to everyone?
Sure. Thanks, John. And thank you again for the opportunity. My name is Mike Pascoe. I'm a partner with Ice Miller in our Cleveland and Philadelphia office, specifically in our construction litigation practice group. I've been working with Keystone Contractors on this now for 10 months. It was a great opportunity, and I think the decision highlights why it's important for organizations like KCA to get involved and to present their view of things. I can't say that it was the ultimate decision maker, but certainly the opinion from the Pennsylvania Supreme Court focuses heavily on public policy implications and legislative implications, and they do acknowledge the submissions from the industry organizations and why that was sort of important in both enacting the law that is at issue here and reaching the ultimate decision that they reached in the case.
Awesome. Before we jump right in, for those who were not following the case, do you want to briefly explain the Clearfield County case and why it was so important for the construction industry to weigh in?
The Clearfield County case really is an example of an excellent test case for an issue like this. Dealt with Clearfield County Jail and construction of that 20 or 30 years ago, significant time ago. And as they were doing roof renovations, they discovered that there was a missing horizontal bond beam. And they contend that Clearfield County contends the remediation cost of that was $3.8 million. And there is a doctrine in Pennsylvania and other states called Nullum Tempus occurrent regi, which essentially means the time does not run against the king. And it applies to statutes of limitations under a public policy that overworked clerks and governmental organizations and various other things should not be held to the same standard as private parties, and that there is a public interest in allowing them to prosecute their claims because it is in everyone's interest. Essentially, municipalities and counties and government do not have their own money. It is just your and my money, or whoever is the taxpayer. And so it is in everyone's best interest to allow them to pursue these claims. There is, separate from a statute of limitations, something called a statute of repose, which statute of limitations is a defense to a claim where if you bring it after a certain period of time, the claim is barred under the law. Versus a statute of repose, and this became a significant part of the opinion, where the statute of repose is essentially an extinguishment of an action. And they bear two different purposes. And so this was an attempt by Clearfield County to apply this Nullum Tempus doctrine that had been limited to statutes of limitations previously to the concept of a statute of repose in the construction industry, arguing essentially that they shouldn't have to bear the $3.8 million, but the contractor and the subcontractor and the designer should be required to do it because they were taking government money and they did a bad job. And the trial court and the appellate court said no. And then it ultimately went up to the Supreme Court, which recently issued an opinion that departed from the rulings of the trial and appellate court and ultimately held that the statute of repose is an absolute bar. It extinguishes causes of actions entirely, and Nullum Tempus would not apply to avoid that absolute extinguishment. So that's the high-level summary of the case and the result.
Nice. I should have mentioned this before we started, but if anyone from the crowd has a question, please feel free to raise your hand or whatever. Or you can type it in the chat or raise your hand on the Zoom, and we'll call you that way. Again, I'm joined by Mike Pascoe of Ice Miller, and we're talking about the Clearfield County case here. So before the Supreme Court ruling, what was the biggest concern contractors and construction companies had about the potential outcome of this case?
We highlighted this in our brief. It was the industry concern, and we were the only amicus to bring this up, is the practical and public policy impacts of this. And essentially what it would mean is, if this doctrine did apply, if you ever did work on a public project in the Commonwealth of Pennsylvania, to be safe, you would need to keep all of your records and documents and everything from that case forever. And we put together some numbers and costs and impacts and just the staggering potential consequences for that. That contractors, especially in Pennsylvania, where we have the Separations Act, and there is a requirement that you bid out all of the prime contracts. It would be a significant impact on a significant number of contractors that every time they did a public project, they would need to archive forever all of the data that they had. And that was one of the main arguments that we advanced in the amicus brief that KCA filed.
Nice. And we do have copies of the amicus brief. A handful of members have requested it. If you have yet to see it, feel free to let me know. Send me a quick email and I'll give it to you. It was great job putting that together, Mike. It's very well documented. So
thank you.
And you kind of just touched on this, but as far as the KCA amicus brief, what made it kind of important enough to get involved? And you kind of touched on it already, but is there any other reasons?
Yeah, and this was actually highlighted in the decision portion from the Supreme Court, where the Supreme Court departed from the arguments of the main litigants and said, that a statute of repose really is a judicial exercise, or I'm sorry, a legislative exercise where the legislature comes forward and says, and they noted that this was advanced by the AIA and AGC and various other industry groups when the statute of repose was enacted, to say, look, we need an outside limit. Our industry as a whole cannot bear unlimited liability for the work that we do. And so we need to set an outer limit. In this case, they set that limit at 12 years. And the KCA's decision to get involved and our unique approach to it compared to some of the other amici is that we really did re-advance that public policy analysis, pointing out that in the modern age, with the advent of email and the massive expansion of data for every single project, that the modern impacts of this would be even more significant than when the statute of repose was enacted in the first place. And so we, from a very practical perspective, submitted a filing to the Pennsylvania Supreme Court that reminded them, look, this is why this law was enacted in the first place. And we need to keep that in mind when you're making this decision, because the previous decisions had focused on whether or not it was a governmental purpose and whether or not it met this test. And it delved deeply into the analysis of Nullum Tempus as a whole and when it applies and when it doesn't. And the Supreme Court said, we don't even need to get there. The statute is very clear. It was enacted for a very specific purpose. And I like to think that the brief that we submitted helped remind the Supreme Court, there are three branches of government: executive, legislative, and judicial. The legislative branch has spoken here and has said, no matter what, at 12 years, the cause of action is extinguished, period, full stop. There were solid public policy reasons to enact it at the time. Those reasons still exist now. And it is not the province of the judicial branch to rewrite the law. And that's ultimately the way the Supreme Court came down.
Yep, exactly. And you kind of, just stated that the Supreme Court ultimately agreed with KCA's argument regarding Nullum Tempus. But how significant was it from a legal standpoint for that ruling?
I think anytime that you settle something that's unsettled, it's good from a legal standpoint. One of the things that we try to do with our construction group when we're advising clients is give them practical advice. Certainly if this had come the other way, I can't practically advise you to keep every shred of paper from every single project that you've ever done whenever you've worked for the government. And so we try to keep an eye on practical best practices. And so one of the biggest problems that we run into is when areas of law are unsettled. And the more certainty that we can get, I harken back to the very beginning of law school, Marbury versus Madison, which says it's emphatically the province of the judicial branch to say what the law is, right? Not to make law, but to say what it is. And so anytime that a judicial branch does that for any industry, it's tremendously helpful. And in this case, it gave us the level of certainty we need to say at year 12 in one day, you don't need it anymore, whatever it is for whatever project you have.
Yeah. Yeah, as you noted, the defense counsel in the case did not advance this argument. Why do you think the amicus brief ended up playing such an important role in the court's decision? And is that common to kind of pick from an amicus brief? Normally when we submit amicus briefs, it's kind of touched on by the defense.
So I think one of the defendants did sort of advance this argument.
Okay.
But their focus really significantly was, and it's unfair to ask them to focus on it differently. They were focused on what the decision was when it was issued below. And so they're really tied up in advancing their positions. And that's one of the reasons why amicus briefs are so important from industry organizations is we come in without an agenda tied to a case or advancing a claim for a client and say, no, hey, as an organization, this is important to us. And we want you, the Pennsylvania Supreme Court, to be aware of what's important to us as an organization. And so, in this case, I think the Supreme Court really kind of came full circle, right? I mean, I do think that the general concept of the public policy of statutes of repose was part of the case, but the parties, I don't want to say were led astray, but they went down a path of responding to what the lower court did. And the Pennsylvania Supreme Court, I don't want to say it takes them to task for it, but notes that the trial level court really did diverge from where, in their opinion, it should have began and ended, which is we have a law, the legislator passed the law, that's the law. There's nothing else we can do about it, right? And that's where they came down ultimately. And so I think when you come in and write an amicus brief, you're freed from we have to advocate for our specific client and win, and you're allowed to advance the public policy issue, which sometimes just page limitations and rules and tables of contents and various other things, you can't get there, right? Or you can't give it the type of support and in-depth analysis that you'd like. And so, I think that they didn't advance it because they had to address so many other things, and we were able to advance it because we weren't required to do that.
Nice. And I do see a hand up. We have John Panzita, president of Panzita Enterprises. Go ahead, John.
So, Mike, is this ruling a broad ruling that it's not just this jails in Clearfield County? It would apply to almost all public buildings. So if I built a courthouse, 15 years ago, I can now sleep at night knowing that if there was something missing, they can't come back, that the statute of repose is in effect.
So it's broader than that, right, John? It's any construction project in the Commonwealth of Pennsylvania that at 12 years there are no more claims. There's an exception for bodily injury that arises in the 11th year and extends past into the 12th year, but beyond that, it is truly what a statute of repose, which is supposed to be, which is that's it. Doesn't matter what it is. Doesn't matter. You could have. I'm trying to think of the most degree. You could have, completely omitted things intentionally and knowingly and gotten away with it. And if you get away with it for 12 years and a day, the case is over. But the public policy of it really, and this is what the Supreme Court focused on, is, look, we build structures and the structures are used and there are impacts on them. And, and maybe they're not maintained, or maybe they are, or maybe there's an earthquake, or maybe any one of a number of a million different things. And so at 12 years in one day, you're absolved of liability for it.
Yeah. And to build off of that and to respond to that, had the court ruled the other way, what are some of the real world consequences for, PNZ Enterprises and other construction companies across Pennsylvania?
I mean, we spoke about this in the brief a little bit, right, John? We talked about the massive, just even cost of potential data storage, and it impacts on smaller companies looking on whether or not they could even engage in that process, right? Because Nullum Tempus is limited just to governmental organizations, right? Recurrent Rajai, right? It doesn't run against the king or the regent. And so, I think that on public projects, governmental institutions already suffer from a dearth of bidders, right? And responsive bidders. And so the more barriers you put in place for organizations being able to do that kind of work, ultimately it's a negative impact, right? And so this all fits within that concept of public policy, and really why that's delegated to the legislature, right? I mean, one of the things that you and I have talked about repeatedly, John, and the organization has been advancing, and really every trade organization in Pennsylvania has been advancing, is getting rid of the Separations Act, and how it just does not work, and all of the issues that come with that. And the legislature has looked at it a couple times, right? They've contemplated it a couple times, and they never quite get there. And it really is a demonstration that, this is not something that is the judiciary's job, right? They're presented with a set of facts in a case in controversy before them, and they make a decision based on what's presented to them. But it's to the legislature to do an analysis of, what is the best public policy, and, should we keep things with weird Latin names from hundreds and hundreds of years ago, right? Or has the time come where we're not going to do that anymore, right? And that is a legislative function, not a judicial function. And the Pennsylvania court really, hit it straight down the center here with that, and said they enacted the law, and the law is the law, and it applies to everyone, right? Even the king.
Nice. Yeah.
Hey, Jon, can I ask a question and actually make another related point? So, first of all, Mike, thank you very much for the presentation. And also thank you for establishing some certainty in the law on this issue, because, if you face or represent a client who's facing a claim on, say, a 20-year-old underground sewage system, they're going to look back on this decision and really hit their knees at night with their prayer hands and say thank you. I mean, the second point is, I agree with you. I think from the perspective of the amicus brief allows you some more latitude. Having written the amicus in bricklayers, I can attest to that. It's a powerful avenue. And, the fact of the matter is, construction cases don't get to the Supreme Court very often. But when they do, the voice of organizations like KCA and CAWP and others certainly need to be heard. And you're the voice. Here's my question. It's not the only repose case that's coming before the Supreme Court. Aloya is in line to be decided. Given I don't know whether you were at the arguments, but given the court's focus on statute of repose here, do you have any tea leaves that you could perhaps fairly read on how the court is looking at the repose in relationship to what Aloya is, which, again, I'll let you get into the details of that if need be.
We did attend the argument, and the argument, it was interesting, and it informs part of the presentation that I'm making here, where the parties really did get into this governmental purpose and function test, and they were examined significantly about whether it is or is not a province of a government to build a jail, and do you have to build a jail, and do you have to have somewhere to house prisoners, and is it a governmental function? And so a tremendous amount of time was spent arguing these various factors and tests and things, because lawyers love to do that, right? And they love to sort of take multi-factor tests and make arguments and try and couch it the way that they think is best for their client. And there were a few questions from the Supreme Court about policy and sort of those things, but by and large, it was an analysis of those factors. And the presentations on those were, I don't want to be critical of them, but it's hard to do, right? It's hard to sort of say, look, I mean, do governments have to have jails? I guess, right? You got to you got to arrest people and put them somewhere, right? But it's a weird sort of arcane path of statutes and various other things. And ultimately, the decision that came out of it, as we said, departed significantly from it and basically said, statute of repose, and that's it, right? And there are two exceptions listed in the statute, and those are the only exceptions, and that's the end of it, right? And so I think to your question, does this resolve it? As far as I can tell, it does. I'm not a Supreme Court justice in Pennsylvania, right. but the decision is not equivocal in any way. It says when we interpret statutes, if the statutes are clear and ambiguous, they mean what they mean. This says 12 years and that's it, except for these limited exceptions. If an exception applies, it's in the statute. If not, there's no exceptions. And that's the end of it.
Appreciate that.
Looking at the Clearfield County case, does anything in this decision change the way contractors should be doing business today, as far as contracts, project admin, insurance, risk management?
I mean, I wish I had a better answer for you, but I would say no, John, right? I mean, it gives them, as John Panzita said, it gives them comfort at night on year 12, day one, that they can never have to think about that case again. So it does really say you can come up with whatever creative argument that you want, fraud or lawful purpose, or any one of these. You can say whatever you want. The statute of repose is statute of repose, and the case is the cause of action is extinguished, and we cannot judicially create a cause of action that does not exist.
Yeah, agree. And I'm glad Ed Gentlecore, I'm glad he brought up the other case. I was going to ask Mike if there's any other cases we should be made aware of, or we should be looking at, and or any other cases you'd like to talk about. But is there anything else beyond that one? Or are there any legal trends we need to be aware of, or challenges that construction companies might be facing legally that KCA should be aware of?
I mean, that's an unfair question. So, John, yes, of course, if we can have a whole an afternoon discussion about the legal trends that I think that we should be concerned of. But I'm gonna rephrase your question as relating to this potential issue. In my reading of this, just from my opinion, does this leave any ambiguity? It does not. It isn't. It's a very well written, to the extent that I'm qualified to opine on what the Pennsylvania Supreme Court does, but it's very well and clear written decision that gives us the certainty we need, that says this is the statute of repose and that's the end of it. And we're not going to hear you no matter what it is you say. I mean, this was $3.8 million, right? And arguably, whoever you believe, arguably according to Clearfield County, obviously, horrifically dangerous, and the roof was floating, and it wasn't attached, it was going to fall in, right? Despite the fact that it had been there for 20 years, it hadn't been a problem, and blah blah blah. But it was as egregious of a case as you could get, and which is why I think it makes good precedent for future issues.
Yep, exactly. Yeah, while it's fun to host the association golf outings and happy hours and all that industry dinners, those are all fun and good. This really hits home why associations are so important when we can produce documents like this amicus brief to help serious issues like this.
So is a notation to your members of, if you are hearing about things like this, right? Whether it's a legal case, whether it's, an issue in the legislature, right? I mean, there are avenues to raise your concerns and make your voice heard, right? In a concerted fashion. And, my encouragement to everyone in the organization is, if you have a concern about these overarching issues, do something about it, right? I mean, encourage Casey to file an amicus brief or reach out to whomever it is you're hearing these things from, right? And realize that, at least in this case, it's a demonstration that historically industry organizations were successful in getting the legislature to enact the statute of repose in the first place, right? For public policy reasons, recognizing that the industry is publicly valued and is important, and a robust quality construction industry in the Commonwealth of Pennsylvania is important. And then also on the judicial side of things, when it comes to interpreting that law, to say, no, right? The legislature knew what it was doing when it enacted this. This is the public policy. You can make whatever public policy you want, argument you want, Clearfield County, but the branch of government that is designated to weigh that, the legislature, who makes what the law is, has already weighed it. And so it's not to us and it's not to you to say that they did that wrong. Go contact your congressperson or senator or whomever you want to and get them to change the law. But until then, 12 years is it.
Yeah, agreed. Thank you so much. You answered all the questions I have. I don't know if anyone on the line has additional questions or concerns or comments. And any sort of feedback whenever you submitted the amicus brief. I don't know the that end of things. I don't know what happens when you submit it. Do you hear from other industry groups or legal at all?
It's the most frustrating thing in the world. You submit it, you hear nothing. An argument gets scheduled. Usually, you'll get last minute notice. You show up and listen on the telephone, or in this case, over the computer, and then you wait anxiously for months, and then you get a decision. And so it's frustrating because there is a lack of control, lack of input, lack of whatever. But it's rewarding when you get the results you want.
Awesome. And these are the results we wanted. So awesome.
Mike, this has nothing to do with the case, but I'm just curious. Do you know if Clearfield County actually spent the $3.8 million to remediate this, or they just got an estimate and based their suit on that?
I have no idea. I mean, I don't want to guess, but if we're off the record and I weren't being recorded, I would guess that there were some kind of split the difference value engineered solution that may not have been as catastrophic as the worst case scenario that was presented in the brief. I mean, the frustration of this for me is, a bond beam is just a piece of rebar, right? I mean, it's not a magical device, right? And I'm not an engineer, but I've litigated cases where someone said, "Hey, there's no bond beam," and what happened is it got moved down a course, or it was omitted because somebody decided that you needed it every 4 courses instead of every 3 courses, or any one of a dozen different, real world value engineering practical decisions that are made on construction projects every single day that aren't ill motive, that aren't bad, that aren't dangerous, that aren't any one of a number of things, right? And nobody knows. I mean, I had a number of cases in Ohio dealing with thin brick veneer cladding that was approved for a while for use outside on buildings. And it ended up being a nightmare because there's not enough air gap behind it for water to evacuate. And then when there's thermal loading, it breaks away from the building in giant sheets, right? But at the time, the engineered specs for the FCC said it was okay, right? And so whose fault is that? And so the the problem that you run into is when the real world and engineering principles and things meet sort of the paper world, and we realize that somebody somewhere who approved something made a mistake. It gets frustrating. And so the thing that was terrifying for me on this is imagine if that liability was unlimited. I just don't know what you would do. So, but I think, John, I would bet, and I'll look now because you made me curious. I'll look and see what they did. But I bet you a steak dinner that it was some form of value engineering that wasn't 3.8. It wasn't $3.8 million, right? That addressed the issue in a way that was safe, but was not some. You got to rip the entire. Essentially, from what I understand, they were saying you had to rip the entire roof off of the building and the top courses of masonry and rebuild the whole thing to tie it in. And I have to think there was a better solution.
Well, it was there for 40 years and there was no issue. So the proof is, you do testing on products to see if they perform. So that building being there for 40 years, pretty good test, The bridge
in Maryland was there for 40 years, and then it got hit by a boat and a bunch of people died. So, I think that the one thing that we have to be cognizant of in our industry, and it's one of the privileges of representing your industry, is that, we build important things for the Commonwealth as a whole, right? And we have to build them right. And we do that, right? And so, I think there is, it stood for 40 years, right? But there's also, you have to meet plant specifications and things. But I really don't think that what happened however many years ago is they just decided to be negligent and not do it, right? I think somebody did something or said something or made a decision somehow where there was a reasoned analysis at the time, but they didn't have the contract, right?
Yeah.
And so
it could have been a deduct change order to eliminate it because they felt it wasn't necessary. But yeah.
Right. Those are right. I doubt that it was a bad actor contractor who just decided we're not going to do that because we want to save a couple bucks. I doubt that that's what happened.
So you brought up the key bridge in Baltimore. I mean, are they suing the engineering firm that designed it because it wasn't designed to withstand a cargo ship hitting it?
Again, right? The state of the infrastructure in our country is very concerning, right? And things need to be done and are being done about that. And that's a whole nother webinar about what we should be doing to spend money to make sure that the roads and bridges we travel are safe, right? I mean, Pennsylvania has the rapid bridge replacement program that we're working on, right? And that's good. I think that and there are states that have enacted laws that say if something that you built hurts someone later, right? And this was, I think, Minnesota. They enacted an exception to the statute of repose and said, and there's a cap on it, there's a reasonable cap on it, but that they can go back and they can pursue contractors and engineers and architects decades later for bad design when people are hurt and killed, right? And that's another public policy balancing act where they say, look, Pennsylvania has a bodily injury exception that extends the statute of repose slightly. Maybe we need to do more than that, right? But what we do know, and I think what the Pennsylvania Supreme Court made clear to bring it full circle to the decision here is that's not their function. That function rests with the legislature.
I'm sorry. Go ahead, Brenda.
I just wanted to ask, were the state and local government agencies or governments, I should say, were they made aware of this new decision? Do they know about this yet?
I mean, I don't know the answer to that, Brenda. Would they be made aware? No. The people who were made aware, I don't know if you guys can see this, right? But there's a carbon copy list on the front of the decision, right? The Office of the Repository, which is the fancy word for clerk of courts in Pennsylvania, sends the opinion to, and it's the litigants and the lawyers for the amici, and that's it. And certainly it's published, right? But there's no blast notice that I'm aware of to local governments or organizations. But I also don't know that there would need to be, because the law is pretty clear that statute of repose is statute of repose. I mean, it was a creative argument, but ultimately, according to the Supreme Court, legally moot.
Yeah. So, John, could I get a copy of that actual
Yeah.
opinion? Thanks.
Yeah. Yeah, and as far as go
I was
ahead,
going to
Ron.
make one more comment. I'm hoping that a tangential benefit of your decision, Mike, is more of these municipalities and states will focus on needed maintenance, because now if they know that they're not going to have the right to go after contractors forever, they might have to actually spend some money to keep these bridges standing, as opposed to perhaps relying on litigation many years down the road. So you might have added that to your checklist and benefit of your contribution as well.
There you go.
Too much credit. And I was just the author of KCA's voice. There were a lot of voices.
So there is no opposition from KCA to send this out to local government to let them know. And I'm more worried about the local governments for sewer water work. So
Send out the decision or
the decision. Yeah, I mean, I
It's
can
public
get
knowledge.
a one page or I can get a one pager that describes it, but they're going to ask you, well, I got to see a copy of it. Our solicitor has to read it, kind of thing.
Brenda, I just sent you a copy of the opinion.
Thank you.
Yeah. And as a result of this case, while it was in moving up the courts, AIA, who has been battling this statute of repose issue in the legislature for a decade plus, I don't know how long, but it's been a really long time. Because of this case, and it was gaining traction and moving up to the Supreme Court, there is a push in Harrisburg to address it legislatively. So stay tuned.
Oh, so they want to change it now.
To lower it, yeah. Yeah, it was just kind of been hanging around for close to 20 years probably. And
They want to lower it below the 12 years?
I believe there's a push I think the legislation is 6 years, I believe.
Well, that's even better for us, isn't it?
Oh yeah, I would think so.
I'll go for that one.
I'll get the facts for sure, but I know it's lowering it. I thought it was 6.
Some other states are in alignment with that six-year period. Ours tends to be out there. Although don't work in New York, there's no repose. So
that's scary.
One other thing I will mention, just to explain myself, though, when I brought up the Aloy case, in that case, which is going in front of the Supreme Court, the question is if there is a failure to comply with building code, does that mean the project was not lawfully performed? And because the statute of repose uses the words lawfully performed, is that a way to avoid the statute of repose? So if you can establish that the building code wasn't followed, can you avoid the statute of repose? That's going to be an interesting question. I'm making the popcorn now. Waiting to hear what the result is.
Yeah. And then for sewer water, would that be contract? You didn't follow your contract?
Well, that's the interesting question. How far they get into that is going to be, I think the question is going to be lawfully performed in the sort of like statutory sense. Like if you don't comply with a building code, did you lawfully perform? So far, the Superior Court said, no, nice try. That's not what they're talking about. They're talking more about, is it somebody who is lawfully performing this function? If they're lawfully performing that function, then they're entitled to the protection of the statute. So, like I said, I'm waiting to see what happens, but I'm comforted by the fact that in the Clearfield case, they seem to have got the point of the repose and why it's out there and why it's doing what it does. So that's all good news. Great.
So
again.
Will KCA be doing an amicus brief on this case you're talking about?
It's a residential case.
It's residential.
It is.
Okay.
Yeah, and I mean that's again, I bet more than the steak dinner that the answer is going to be no, and that it's just not. The statute of repose is the Clearfield decision is the statute of repose is the statute of repose. Repose means it's over. It does not exist.
Mm-hmm. Speaking of that, though, since both cases were kind of mentioned in the same breath the past year or so, can briefs be used for both, or is this specific only, is ours only for this case then, that the Supreme Court?
We could refile the amicus brief. I mean, I think the issue, I just don't see how they would square that circle if they then came out and said, oh, but I mean, it's just a defect, right? It's a construction defect. Just because it happens to not match a code doesn't make it a special kind of defect that magically exempts you from any time limit. I mean, that's silliness. That's Mike Pascoe's opinion, nothing more.
There you go.
Never try to guess the Supreme Court.
Yeah.
Well, I just don't. I mean, you could argue, right, that this failed to meet. So you could find some building code that you could argue this, wind uplift or some kind of other whatever. I don't know, nonsense that there's no such thing as magical language.
Someone has been doing this for 40 years. There's a code violation in every completed building project.
I mean, look, in my house, I just recently discovered that the previous homeowner, instead of putting built in the early 1900s, instead of putting junction boxes in when she put fans in, she just screwed them into the lid in the ceiling. It's a code violation, and a fun thing to remedy. But look, I mean, to your point, right? The house didn't catch on fire. Doesn't mean it's okay. They all have boxes now. So.
Yeah. Any other questions? Comments?
I've learned a lot. Thank you, guys. This is not my line of work. I recently joined Pro A, and sitting in this call, I learned a lot. So thank you.
Awesome. Glad you could join us. And there were more that registered, but there were some issues with yesterday's schedule. So we had to postpone it and hold it today. But we are going to have it recorded and posted on YouTube, so those that couldn't make it today, so they could see it. But on behalf of the KCA, I just want to, personally thank Mike again for the great work on the amicus brief and for tracking this issue and keeping us up to date on it.
Yeah, and shout out to my team, Rob Port and Alan Petrollo, who jumped in and helped with the brief as well.
And shout out to John Panzita and the other members of our working committee that met with your team a handful of times to make sure we had the strong 3 points in our brief. So thank you, John, and thank you, Mike, and thank you to everyone else for joining us today. Have a great day.
Thank you.
Take care. Thank you.
Great job, Mike.